Hello, everyone. My name is Jonathan Freebird. I'm the Director External Affairs at Microsoft and run the Voices for Innovation program. We're very happy that you're able to join us today for what I think will be a very important and informative webinar on the general data privacy regulation and compliance with that. We have two really terrific people with us who can talk through what you need to know about GDPR. So we have with us Phil Armstrong and Brendyn Ryan. They are both commercial attorneys supporting Microsoft's One Commercial Partner Team and partner-related business desks, in addition to supporting Microsoft's business teams through partner recruitment, build with, and co-sell cycles. Phil and Brendyn regularly work with partners to address compliance questions with a focus on the EU's General Data Protection Regulation. So, like I said, we have two great people with us. So one last reminder, please mute, and we will take questions at the end. So Brendyn, Phil, I'll turn it over to you.
Thanks so much, Jonathan. And first, this is Philip Armstrong, I'd like to, first of all, thank everyone for taking time out of your busy schedule to come listen to this webinar. The Voices for Innovation program is really valuable for us here at Microsoft, and so we really appreciate this opportunity to speak to you and hopefully provide some interesting information that you can use to help you with your compliance concerns around GDPR. As Jonathan mentioned, Brendyn and I support the One Commercial Partner business worldwide here at Microsoft, and so because of that, we really sit at an intersection from a GDPR perspective between the obligations that Microsoft will have in its capacity as a controller internally and the obligations that Microsoft will have in its capacity as a data processor, which is working on behalf of our customers. So Brendyn and our focus has been both on what we can do to help our partners like you meet your compliance obligations under GDPR to the extent you have any, and in addition to that, also how we can help our customers, which probably are some of you as well, that meet those obligations as well. GDPR, Jonathan, why don't we go ahead one slide? GDPR, as you probably know, is coming into force in May of this year, and we openly acknowledge that and that the GDPR is setting a new and higher bar for privacy rights, security, and compliance around the world. But we see this as Microsoft really sees this as an important step forward in clarifying and enabling these individual privacy rights. And I think from an EU perspective, and I know most of the people on the call are based in the US, but from an EU perspective, the GDPR is really an incremental step in advancing their privacy laws, which haven't moved forward in about the last 20 years. And so a lot of what GDPR is doing is actually codifying into the regulation decisions that have been made with respect to the existing privacy data protection directive, but it definitely goes beyond that. I think one additional concern that will be for the people on this call is much more so than the current data protection protective directive. The GDPR actually has more of a broad extraterritoriality effect, and so it has the potential to impact companies that don't have a footprint in Europe, but are selling goods and services or monitoring individuals who are in Europe. So I think that's definitely causing a concern, and Brendyn and I have been working with our field lawyer teams as well as with customers and looking into this issue and trying to understand the impact that it could have. Jonathan, if you could go forward one more. So what's interesting is with so many people on the call, it's somewhat difficult to know where you all are at in your GDPR journey, and so I think we'll kind of start at a high level here, but this is just a general summary of what's changing with the GDPR. As you can see, there's on the right side there's additional enhanced privacy rights for data subjects or individuals. There's an increased duty on companies to protect data. For people based in the U.S., this is a minor step, or probably not much of a change at all, regarding mandatory breach reporting. However, in the EU, this is actually viewed as one of the bigger changes that's coming with GDPR, is this obligation to report security breaches that involve personal data. And finally, there's significant penalties for noncompliance. We won't dwell on that. We may chat about it a little bit more, but compared to the existing Data Protective Directive, there's no question the penalties are significantly higher. Now, one of the things, just going to the description on the left here, is this kind of summarizes the scope of the GDPR, and so the GDPR applies to organizations that are based in the European Union, but it also applies to organizations who are not based in the European Union, to the extent those organizations either offer goods or services to people in the EU, or collect and analyze data tied to EU residents. So that's where a company who is based in the US, who doesn't have any European footprint at all, but could still get caught in and be subject to the GDPR. So if your company does not have what they call an establishment in the EU, and an establishment is a fairly low bar under the current Data Protective Directive. So a single employee in Europe working based there could create, under the existing laws, could create an establishment in the EU. So that would then pull in the GDPR immediately. But even if you don't have that, if your company or your organization is offering goods or services to individuals who are based in the EU, or are collecting or analyzing data from individuals who are based in the EU, who are resident in the EU, then the GDPR will apply to your organization. And there's a lot of misconception around it, whether or not it applies to EU nationals, no matter where they are. So, for example, if your company, is based in the U.S., it has no individuals in Europe, it only sells to companies locally, but it happens to have an employee who is from Denmark, has a Danish passport, but is resident in the U.S., and that's the only tie. In that case, the GDPR wouldn't apply to your organization. But you could have a situation on the other end of the coin where you have, an employee who is Canadian, who is based in the EU. Well, then actually it would apply, because you have an employee based in Europe, and it doesn't matter whether or not that individual is a European citizen or whether or not they are from another nation. So that's an area where I think there's been some confusion, and I think when we get a lot of questions from customers and partners who are based outside the EU on that point. So I hope that's helpful for you. I hope for some of you it means you're breathing a bit of a sigh of relief, and for others, I think it may have the opposite effect of realizing that it's more likely that this regulation may apply to your organization. Jonathan, can you go forward a slide, please? So from a high level, this slide looks at what are the key changes that are coming via the GDPR. And one of the things when you hear about the GDPR, you may hear people talk about data subject rights. And if you look at this slide on the leftmost column, the personal privacy column there, that's really a summary of what the data subject rights are. And again, from an EU perspective, there's not much new here. Like the third bullet down, you see the individuals have the right to erase their personal data. We usually hear this called the right to be forgotten here in the US. In the EU, they often refer to it as the right of erasure. There's also the rights to have access to their data, to correct errors in it. The data has to be accurate. In certain circumstances, if the individual can request to have their data deleted, but there are carve-outs for that for certain sorts of lawful processing, lawful obligations. So, for example, if an employee in Europe asked, you quit their job and then asked their company to delete all that employee's personal data that the former employer has, well, the former employer may have obligations under European law for tax reporting or other obligations, and so in those circumstances, the company can choose not to erase that data. However, the individual can also object to having that data processed for any purpose other than storage or for the purpose of tax reporting. So that's something that's baked into these data subject rights. In addition, there's the obligation to allow individuals to export their personal data, so they can ask for a copy of it, and then it has to be then they can take that to a different, for example, in the cloud, it could be a situation where a customer wants to move from one cloud provider to the other, and so under the GDPR, there's an obligation to provide that. Now, that's something we would do in any event, so it's not a big change for Microsoft, but it is something that would be applying for all companies. The GDPR also puts much stronger requirements in around security. And so as you see in the second column there, the additional requirements around controls and notifications. So there's a much higher degree of security required, though the statute, as you can imagine, is written with a large degree of vagueness. It has to be appropriate security, and so it doesn't prescribe certain requirements, which is generally a good thing, because as security increases, as we get better with our technology at protecting data, we should, the rising tide should float all the boats, and then the security should be protected for everyone. As I mentioned before, there's data breach notification requirements, and these can get somewhat complicated because the requirements are different for a controller of data. So that would be personal data that you control with respect to, for example, your employees or your customers, to the extent that you are acting as a processor, which for Microsoft is, when we're providing cloud services to our customers, in that situation, we would be considered acting as a processor, and on behalf of our customer, who would be the controller. In that case, the data breach requirements, the timings, and the obligations are slightly different. So there's some nuance in there, and if you are acting as a data processor on behalf of other entities based in the EU, then this is something that's a nuance that you might want to have your lawyers look into. James, thank you for the question. Will Britain comply with GDPR after leaving the EU? That's a great question. Our understanding is yes, that the GDPR will what our EU CELA team has told us, our UK-based CELA team has told us, is that our understanding is currently Britain intends to basically create a mirror version of the GDPR that will continue to apply even after the Brexit is completed in about 2 years from now. So I think given that GDPR comes into force in a few months, I think we should view it as if you're looking at Britain, this is something you should keep in mind. And the other thing to think of as well, just broadly about GDPR, is the reality is the world looks for, with respect to privacy law, the world looks to the EU as a leader. And so in addition to this question about Britain, we're actually seeing copycat GDPRs starting to pop up even already. For example, the cybersecurity law in China, which was recently enacted, once they got a hold of the GDPR, they actually made some changes to it to make it look more like the GDPR. We understand that South Africa is setting up a GDPR-like statute as well. So we think you're going to see more and more countries around the world enacting essentially copycat laws that will mimic the GDPR. So by looking at getting compliant with GDPR, we think that will help companies who may not be doing business in the U.S. In the EU, but it may be doing it in other countries around the world, and we could see these issues popping up. To U.S. agency info in 365. Jonathan, I'm not an expert on U.S. public sector agency related issues, but to the extent, if it's the GDPR applies to personal data with respect to EU individuals, and looking back at the previous slide about how it applies externally, I think it is theoretically possible that the GDPR could apply to a U.S. Agency. However, how they would enforce it would be a different question, which we can come to later. Yeah, I'll hit some of these questions a little bit later in the presentation, but thank you for putting them in. There's a slide later on which I think we can talk a bit about that. So just from a general GDPR perspective, in addition, going back to the slide, one of the big points here is regarding the policies that have to get put into place. Part of the GDPR requirement is a lot of additional documentation, which you see in that transparent policy section. And this is an area where we'd like to talk a bit about how, for customers using our cloud, we think our cloud will assist our customers in meeting their GDPR compliance requirements, especially around security. However, it really is a distributed set of responsibilities, and so, for example, we can by putting your data in our cloud, our security will help protect that data. However, in addition to having the distributed responsibility of your organization setting up proper passwords and things like that on the security side, the GDPR will also require these additional policies to be put into place, and that's something that our customers and your organizations would have to do internally, as those policies would be appropriate for your organization, and each organization is going to have to come to a different set of policies given their business and how they operate. Also, finally, as the final column indicates, from an IT and training perspective, there's a lot more requirements in GDPR regarding training and being able to document that training in a way that's auditable, so that in the event that an issue arises, or a request from a regulator comes, that documentation is available and can be provided to a regulator. Let me just look at the question. So we'll address in the Q&A period. Thank you, Brendyn. Jonathan, can you go ahead a slide? Thank you. So at the end of the day, what does all this mean for personal data? And this, as we mentioned, there's stricter controls about how personal data is used and stored. A requirement for better governance tools to provide transparency and record keeping and reporting, and in addition, improved data policies are required to really give control to data subjects, which again are individuals based in the EU, and to ensure that any data that's being processed is being processed lawfully. Jonathan, can you advance the slide, please? Thank you. So for Microsoft, what does this mean? So we have already published in our online services terms, the OST as we refer to it, down below you can see a link. We've already published our GDPR commitments. We were the first hyperscale cloud provider to do that. They're publicly available. You can go take a look and see how we are making our contractual commitments to comply with GDPR. We were also the first major cloud provider to publicly state that we will be compliant with GDPR by May 25th, and those compliance obligations would be with respect to us as a controller for our internal HR data and for our consumer business data, but also with respect to our obligations as a processor of the data on behalf of our customers. Now, one of the questions we get a lot from partners in particular regarding GDPR is, what's Microsoft doing? And I think this slide demonstrates how we are providing our GDPR commitments to our customers. Often a lot of our partners are interested in how we're enforcing or putting the GDPR obligations on our vendors, on our sub-processors. And it's not on this slide, but it's actually also publicly available. If you go to Microsoft.com and look at our supplier page, you can go there and on that page for our suppliers or our vendors, there's a copy, a publicly available version of our master supplier agreement, our MSSA, and in that agreement, we've already updated the terms around privacy to reflect how we're pushing GDPR requirements down to our vendors to the extent they're dealing with personal data. So I think for a lot of our partners, that's a valuable thing to go take a look at, because you can see what we're presenting to our customers, and then how we are looking at pushing that obligation down to our sub-processors as necessary. So that would be something I would encourage you to look at if that's a concern for your entity. Jonathan, feel free to go ahead. And you can click through one more. I think this slide has, it fills in. So the top GDPR considerations to look at, again, as we mentioned, there's the expanded scope, the expanded territorial reach. There's also, if you look on the right side of the slide, obtaining consent is also a fairly big concern, as the consent has to be very clear and unambiguous and freely given. So the consent requirements are definitely stricter than what was there before. Going to some of the questions in the window regarding expanded territorial reach. As I mentioned, for example, if you're a company based in the US, but you sell goods to the EU and you have a website that's you can translate it into French and Danish maybe, and you actively ship goods or provide services in the EU, then that's something where the GDPR would apply. Now the question then becomes, how will the EU enforce the GDPR against an entity that's not based in the EU? Well, that's a very good question, and it's at this point it's still a very hypothetical question because the statute is new and it's never been litigated and gone to court. So please understand that what we're talking about here is all conjecture at this point. But one of the things to consider is if your entity actually has an EU establishment, an employee or a company based in the EU, then that would be something that where if there was a GDPR issue and a fine was issued by a regulator, it could be enforced against the entity in the EU. However, if the European regulator was trying to enforce a fine against an entity in the US that didn't have that establishment, it's true. We think it would actually be a lot more difficult for them to do. Wouldn't say it's impossible, but generally, an American court would not look at a fine from a European entity as something that they would enforce in the U.S. However, one of the things that people, when they look at the GDPR, another issue with the GDPR is that it creates essentially a class action lawsuit ability. So if the European individuals launched a class action lawsuit against a U.S. company and won in the EU, and then tried to bring that the award that was granted in Europe to the U.S., that's actually something that a U.S. court would likely enforce in the U.S. Obviously, there's a lot of issues around there, but it is something where there is a significant more risk of that being enforced as opposed to a standard fine that would be issued by a regulator. Another option that the GDPR regulators could have would be theoretically issuing an order telling your customers in the EU not to share any data with you. That's also something that, again, it's all conjecture at this point because it's never actually been litigated. We don't know, but I think from our point of view, it would be, I know a lot of companies have looked at it and said, well, if they can't enforce it against me, I don't know why I should comply. And again, I think the risk is that it is still possible that there are ways in which it's possible that it could impact your company. And I think the reality is that we're going to see more and more GDPRs popping up around the world, and GDPR-like statutes popping up around the world. And so it's going to become unavoidable, I think, is the reality, a lot of these obligations. The other thing to consider is your customers in the EU have an obligation to ensure that their processors are GDPR compliant. So what you'll also get is, and we're seeing this on our end as well, is a lot of our customers are starting to send questionnaires to us asking us to demonstrate how we comply with GDPR. And if we can't complete that questionnaire, then they're going to take their business elsewhere. So I think there may be ways to try to avoid it. That being said, you could also see how it could have a pretty negative impact on potential business opportunities, as well as I mentioned before, there's a real likelihood that we're going to see more and more of these popping up worldwide. So I hope that answered some of the questions we had raised previously. Where are we at for time? Jonathan, do you want to maybe go ahead 2 slides? This slide actually just try to demonstrate how GDPR is very complicated, and as we'll see on the next slide, it impacts in various different parts of the organization. And so having this kind of broad portfolio, we think will help you meet your GDPR obligations, because there's Jonathan, it looks like, okay, there you go. So how to get started. And this is really high level, but the reality is, we get asked questions, like as I mentioned before, we're frequently asked, how's Microsoft approaching this? And we're a hyperscale cloud provider, so our business is very different from most other companies' businesses, and so how we approach it is going to be different. That being said, this is a very high level. This is actually what we at Microsoft are doing, and we're fairly far down in our journey. But really, the four pillars we have there is discover, identifying what personal data that you may have and where it resides, manage, governing how this personal data is used and accessed, protect, establishing security controls, and being able to detect and respond to data breaches and other vulnerabilities, and finally reporting, having the necessary documentation available, how to manage data requests from data subjects, and how to provide breach notifications. Jonathan, do you want to go ahead? Another slide.
Yes, my PowerPoint is crashing, so maybe if you want to
do you
talk...
want me to here? Let me try to present then.
Thank you. I can give control to you.
To load here. All right, it's just uploading. Sorry about this, everyone. And so, and I mean, I think at this point we're getting the most of the rest of the deck as it's loading up here kind of walks through those 4 steps that Jonathan was just showing: the discover, manage, protect, and report. And they give examples of existing. Oh, here we are. Existing Microsoft products which you can use to help you discover where this personal data is and how you can manage it. There we are here. And what you might be able to use. And for a lot of you, you may actually already have access to these sort of cloud. If you've got Office 365 E5, then a lot of these Office and Office 365 products are already available to you, and you can already get going looking at it. I think here, in this Discover slide as well, this on the left column, this list here is the list of really. This is the list of what is personal data under the GDPR. It's any data with respect to an identified or identifiable person. So if it's data that in its own can't identify an individual, but when combined with other data can then re-identify the person, then it would actually be considered personal data. So you have here, the name, the email address, social media, bank details, IP addresses, cookies. These are all considered personal data. And so I think one of the questions was asked earlier was about interview notes of a job candidate. Well, if the job candidate is a European national, well, not even that. If it's a job candidate, and the GDPR is subject to you're subject to the GDPR. Well, given that their name is involved, that would make it personal data right away. To the extent if you remove the name and there was no way to link those notes back to the individual or to identify them, then that would be something where you could argue that it actually isn't personal data. So I encourage you after this, Jonathan, I think you're going to make the slides available. You can go through and look at the slides here and get more information. As well, I think one of the key things we want to leave you with is if you go to our Trust Center, you can find a lot more information about how we're going to comply with GDPR. In the Trust Center, Lisa has our publicly available GDPR page. Some of these other resources that we make available, we have an assessment tool that's up there. There's 2 versions of it. You can log in and run through the tool, download the tool and run through it, and I think it'll help you understand where you're at on your GDPR journey. We have lots of white papers and guidance, FAQs, and then links to solutions. And as you know, we're still on our GDPR journey. We're getting close, but there's still a few months left to get compliant, and as we make changes to our system and make new tools and available for our customers and our partners, this is where you're going to find them. So I'd highly recommend bookmarking this site so that you can go back and take a look as things get updated. So that's the base of the presentation. I know we've got a number of questions that have come in, so we can turn to those now. If people have other questions, feel free to put them in the IM window.
Thanks, Phil. This is Brendyn. I'll jump to, I think, one of the earlier questions that I don't believe we've addressed it, and then we can work our way down the IM. One of the first questions was, to what extent does Privacy Shield certification cover GDPR compliance?
Thanks, Brendyn. That's a great question, Ovi. So Privacy Shield certification is dealing with data transfers out of the EU into another another country, and in this case, Privacy Shield is, of course, specific to the US. So under the GDPR, if data is being transferred out of the EU, it has to be done in a compliant manner, which for a lot of companies in the US would mean pursuant to the Privacy Shield certification. But that's only one small component of the GDPR. So being Privacy Shield certified alone is not sufficient to say you're GDPR compliant. So the GDPR's obligations, as we mentioned before, are actually significantly broader than just the data transfer portion. So if you think of Privacy Shield as simply as a data transfer mechanism, on that point, you could, if the entity you're working with is Privacy Shield certified, then that's a box you could tick is on the data transfer side, but it doesn't touch with respect to managing personal data or locating it or keeping it secure. It's really just that transfer obligation.
Yeah, and just I think Phil nailed it. I think the other point is people should not walk away thinking Privacy Shield certification is sufficient. Relevant, important, but doesn't cover all of GDPR. So hopefully there's no confusion there. And then Phil, the next set of questions came from, looks like from David, and it's regarding the U.S.-Canada Spam Act, and it's all about not using false or misleading headers, deceptive subject lines, those sorts of things. And then the first question is, there's no opt-in or an opt. Let's see. So how does GDPR intersect with the Canada spam for European citizens?
You know, David, that's I'm not an expert on the CAN-SPAM Act, but I think let me just see here.
Yeah, I've got a couple of thoughts, Phil, as well.
Go ahead, Brendyn.
That are a little bit more general in nature. There are going to be instances where regulations, laws around the world seem to conflict with GDPR requirements. I'm not saying necessarily that this specific act will, but there are times where we know companies will have data retention requirements, and depending upon the industry, you may need to retain certain information for a particular period of time, and you can imagine a scenario where you've got a data retention requirement, and then that might conflict with a request from a data subject to erase data. So how all of these things work out in the end, I think some of it may ultimately be litigated, but you're going to have to go on a scenario by scenario basis. You'll probably have to engage maybe an attorney, maybe a GDPR expert to assess how your company is implementing, for example, requirements regarding the Canada spam rules. Compare that to what you're doing with the data, what the GDPR requirements are. You'll have to look to see if there are conflicts between what you can do under the Canada Spam Act and what's required under GDPR. And then you're going to have to make an assessment as to whether that's going to change. You're going to have to change your practices, whether certain regulations or requirements are going to provide you a legitimate business interest in which you might be able to not act upon a specific data subject request. So I think for each regulation where you're trying to figure out how they harmonize and if they harmonize, that's going to be a case-by-case basis, and it's hard to make a blanket statement about how they will all work together. Phil, do you have any different or additional thoughts?
No, I mean, I think that's right. I've just been scrolling, David. I've been trying to read the full thread while Brendyn was talking, and I think, I think there's some overlap, but I think, I mean, you could probably think of it as, GDPR applies with respect to the personal data, but it looks to me like when looking at the CAN-SPAM Act, I mean, this is regarding how we communicate or how your company communicates with your recipients. So I don't think it looks like these two sets of obligations could probably exist in parallel, but for example, if you're the EU, there's no formal opt-in under GDPR, but there is the consent requirement. So if you're if you're going to be processing a European citizen's data, then and they are based in Europe, then you would argue that, well, if you have an opt-in, then you have a consent, and so I think there's some overlap where likely you may find that the GDPR and CAN-SPAM actually are moving in parallel, and by complying with one, you're also ticking the box on the other. But I think Brendyn's right. At the end of the day, you're probably going to have to sit down with your legal team and look at these in more details, as neither of us have dug into this particular issue.
And can I just add, this is Jonathan Freibert, one other point, and this is kind of where VFI fits into all this, just for perspective. I think, communicating to elected officials and folks who are, in charge of, if you will, passing the laws, creating the laws, and telling them if you're having challenges like what we're talking about, where there's conflicting laws, even if it is, regulations in Europe versus what's in the U.S. These are important points that I think that you can make to elected officials, and what we try to help you do through the VFI program. So we're at time. Brendyn, Phil, do you want to? There's a couple other questions. I don't know if you want maybe time for one more, and then we can. I'll send out email to everyone, with a link to the recording and the slides. I'll include the slides, and then if there's follow up, I'm happy to help facilitate that. But maybe one last question, and I'll let you guys choose which question you want to answer.
I think Obi's follow-on question here about processing data. If you the question is whether or not you need consent to process data if it's needed for a service you provide. And Avi, you're correct that there's a what the GDPR requires is that the processing be lawful. And there's a couple ways that it's set out in this is in Article 6 of the GDPR. So consent is one of the big ones, but if the processing is necessary to comply with the legal obligation, or if it's necessary in connection with the performance of an existing contract where the data subject is a party, then that is something where you don't need a second consent because it's already part of the contract in place. The nuance on that, though, is the depends who is the counterparty to the contract. So if the counterparty is the individual, then they are then it would be you could probably take off that box. But if the counterparty is a company and these are the employees of the company, then it's more difficult to say whether or not you could rely on that exception. So, but it is true there are some other ways in which the processing can be considered lawful, including a legitimate interest test, that you have a legitimate interest in processing the data. But that would again be something you'd want to walk through with legal advisors in more detail and make sure that you have the right way in place. So thanks very much, everyone.
Thank you, Phil. Thank you, Brendyn.
Really appreciate it. I appreciate your time.
And before, thank you again, everyone, and thank you for the great questions. Thank you for everybody who participated. Again, I will follow up with you with the recording, with a link to the recording, as well as the slides. Before everyone leaves, I just wanted to make a plug for our next webinar, which will be on Wednesday, January 31st. It's going to be a little unique for VFI in that we're going to have two entrepreneurs and authors who just released their book, Shortcut Your Startup, and we're just going to have a conversation around entrepreneurship and tips and tricks for running and growing your business. So we will be promoting that as well and encourage you to participate. So again, thank you, everyone, and have a great rest of your day. And again, thank you, Phil and Brendyn, for a great presentation.
That was great. Thank you very much.
All right. Thank you. Bye now.
Thanks, everyone.